पंखा बंद कर दो।
Yes.
May I please your lordship? My lord, I pray for adjournment of the matter, my lord. Yesterday I have filed a slip, my lord.
Which case?
Item number 3, my lord.
Have you seen the note at top of the call list? These
Lordship.
are old matters. Why should
My
we
lord,
adjourn?
The fact now is that, my lord, the company is under liquidation, my lord. Shall have to impede the liquidator. Hindustan Paper Corporation, my lord.
When counsel for the appellant state that as the respondent company has gone in liquidation, the official liquidator will have to be impeded as a party respondent in the writ appeal. The praise for is granted 2 weeks time to do the needful. Let's talk 2 weeks.
I'm obliged, lord.
May please, the lordship.
Yes.
Lordship, item number 9. May I?
9.
Lordship.
What do you want?
On Monday, lordship, as because I am not well, lordship.
When counsel for the appellant submit that he is not well. Mr. Haq, submit that you are, Mr. Haq,
Yes, Lord.
submit that he is not well today and request for a short accommodation. Please stop to 1 week.
But on Monday, lordship, if possible.
All right, let's do Monday.
Highly blessed.
My pleasure. Lordship, I can 13 to 25. May I pray not to 13?
13.
Yes.
Why this is a bunch? Why have you
Yes.
filed
At
who
least
has filed the,
For today, Lordship. I
Why?
pray adjournment for today. Yesterday I have filed a slip also.
why?
Uh,
Any specific reason?
no.
Then for no good reason, we should attend the matter. Simply because you have filed a slip. That's not fair.
For today, next Tuesday, Lordship.
But there has to be a reason.
Regional Lordship, actually, so many petition is there.
So many.
All the petition could not be gone through at a time, my Lordship. Yeah.
We'll take it up one at a time. Don't worry. Let's see. Let's call out the matters, then we'll see.
Lordship.
Lordship, with regard to item number 31 to 33, your lordship.
Hmm.
Lordship, yesterday you have filed an affidavit in reply, your lordship, in item number 31, your lordship.
31 to
31 to 33, your lordship, these are fact matters, lordship. I am for the appellant in item number 31. I'm praying for a week time, lordship, 2 weeks time.
And what about the other matter, Dr.
Lordship,
Saraf is
ma-
representing?
Yes, senior counsel, Mr. Azhar,
Do you have any
therefore the
objection?
PNB.
No,
My lord,
And counsel,
only a
Mr.
short date may be given. Only my short prayer is the short date may be given.
Affidavit in reply has been filed in writ appeal number 300 of 2021. The same be brought on record, re-notify the petitions after 2 weeks.
So did the interim, my lord.
Interim order passed in WPC 6562
Yes,
Yes,
and
Lord.
4333 of 22 shall continue. Obliged. Till
Much-
next date.
Much obliged, lordship.
Is there any interim order in your case also?
No, lordship, I have been asked to payment, to give a payment, I have done that, your lordship.
Okay, very well.
Much obliged.
May I please, your lordship? With regard to item number 60 of the supplementary list.
60
60, my lord.
criminal appeals.
Criminal appeals.
Why?
It
What
came up
happened?
Suddenly, my lord, I couldn't prepare, I was not well. I couldn't
Suddenly?
prepare it. It suddenly came up in the supplementary list, 8:45 PM. my lord.
Oh,
I couldn't prepare it.
8:45 supplementary was circulated yesterday.
Yesterday only. my lord.
Then, so
Couldn't
what
prepare
is it? Is it a rocket science?
Nothing.
Criminal appeal, we'll read
Just
the
waiting
judgment
for a
together.
Short date, my lord. Next Wednesday.
Counsel for the appellant pays for time, list up to 2 weeks.
Obliged.
Daily list for orders, item 6.
Yes.
May it please your lordship.
What is there in merits? What is there in your case in merits? Tell us.
Actually, Lordship, we have another issue. Lordship, we have filed and read appeal along with a IA for delay condonation on 18th July. Then for the read number 977/2016. Then my lord, on 26th July, we have filed this appeal along with a IA, which was on the 4074. But my lord, the
For the,
4074
Yes.
2016
yes.
read number, my lord.
Hmm.
The my lord issue is the 4074 is the subsequent development read on the 977.
Hmm.
So my lord, my request is the 977 should be come first in the list, but my lord, in today's daily list, the 4074 has come. So my lord, on the next day, the both matter may be come together.
And counsel for the appellant submits that another analogous appeal has been filed in connection with writ appeal in connection with writ petition number
My lord, 977/2016.
977 of 2016. She prays that the said appeal may also be tagged with this writ appeal. Registered to do the needful and list both the matters together
Milord,
after a week.
our name has been shown as a SC Seba. Seba is not a made party in this appeal, my lord. My name
SC Seva is there.
No, my lord, there is no party, my
See
lord.
the cause list, please.
All this I have seen, but in the writ appeal, my lord, we have not
Writ
made
appeal
party.
you have not included, then how it will come in the cause list?
That's why, my lord.
But then you make an objection. Yes, yes, Seba.
Seba is not made party, my lord.
Seba was a party in the writ petition.
But there was a repetition, but there is party, my lord. There was implemented as a party.
Let's
But in
see,
the writ
let's see.
appeal, my lord, they have not made party.
Let us check if Seba was a party in the writ petition, please.
Repetition, in printed repetition, there is no, my lord. That was by.
Seba was not a party in the writ petition. So why are we so required to make them a
Yeah.
party? We'll consider when both the matters come up. Yes, see, Seba cause list mein kyun dala hai? Why they have mentioned it in the cause list? When they were neither party here nor in the writ petition. Anyhow, find out.
Item number 7.
I 26 days delay, my lord.
What is there on merits? None of your candidates is a graduate. How they are entitled to be promoted? Tell us.
Lordship,
Now,
one,
Mr. Nayak,
Lordship,
we'll condone
one
the
more
delay.
issue. Lordship, one more issue
Yes.
is there, Lordship. Their services were regularized in the year 2005, Lordship,
Hmm.
against personal post, Lordship.
That we have seen.
Lordship, that judgment, your Lordship has
There's already one judgment on that issue.
Judgment is already there.
That's right. That is referred to in the single bench order.
Yes, Lord.
But the larger issue is that if they don't have the qualification, how
That is
they'll
right.
get promotion?
Yes.
Anyhow, we'll condone the delay and decide the writ appeal on merits.
Lordship.
Delay condone, writ appeal be numbered and listed for admission after 1 week. Delay of 28 days.
Item number 8.
May I please your lordship? Mr. Sharma is in legs. Kindly pass over the. matter
Third
for
issue
the-
notice of the interlocutory application seeking condonation of delay to the respondent. Steps for service be taken in 7 days whereafter process be issued. Rule is made returnable in 3 weeks. 4 weeks.
Bless.
Item number 10.
No one for the state. None present, list after 1 week.
Item number 11.
Lordship, there is a common judgment, Lordship. I had filed another case, Lordship, and IA also, Lordship. Another case, Lordship, common judgment was there, Lordship.
There was one more writ appeal.
Another appeal is there,
So
Lordship.
do you want this to be deferred?
Lordship, they may be taken up together, Lordship.
Uh,
That will be convenient to your Lordship because some.
All right, Ms. Bhagwati, submit that another analogous writ appeal number
Lordship, filing number is there, Lordship, WA.
within bracket filing number so and so
755.
has been preferred in this matter. And that it will be desirable to hear both the matters together. List is directed to a list to number the said writ appeal within bracket if subject to removal of defects if cardinal bracket closed, and list both the matters together
Lordship,
after 1 week.
Lordship. Much obliged.
Item number 12.
What's the matter? People are in a slumber today or what? Hmm. None present, list up 4 weeks.
Item number 13 to 25.
Yes. The appellant's counsel will say that there's an adjournment slip. That is a problem. What is the controversy? Just let us know
Yeah.
what is the brief controversy.
Regarding my lord, the fire price shop,
Hmm?
those who are having 50 or less than 50 ration card.
Okay, this is that
they-
matter of ration cards.
Ration
All right.
Yes.
So when do you want the matters to be taken up?
Next week, my lord, next Tuesday.
Counsel for the respondent. Yes,
My
madam.
lord, can it be taken on 8th of this month?
8th of
8th
August.
August, my lord.
This is Tuesday.
8th August, we have already fixed many matters, madam. And counsel for the respondent has circulated an adjournment slip, re-notify for hearing on 24th August. Re-notify for final disposal.
Top of the list matter. Item 1.
Deeply obliged.
Please, Lordship.
Is there any live issue now left in this?
No, my lord. Selection was made in 2009, appointment made, and the persons were
But
promoted
then
also.
the issue is, Mr. Roy, the issue is that you have changed the rules of selection in midst of the game.
We have not.
Reduced. Why only the marks for the written test were reduced? Why not? That doesn't it give rise to a suspicion or an inference
No,
that
my
you
lord.
wanted to favor a particular set of candidates?
My lord, in the advertisement, we have only said that written test will be in two parts, 60 and 60. We have not said anything about group discussion or interview. No marks were. After the written test was held, if your lordship kindly have a look.
So
for
the
what-
marks for interview were fixed after the written test. They were
Yes.
not there in the original scheme.
Not there.
Then how could you have done that?
But not, that's why your lordship will kindly have a look at page 15. That is the scheme, my lord.
50.
1-5.
1-5.
1-5. My lord, 1-5, in fact, yes, 1-5, it is the guideline given after the written test was held. Because the selection procedure was adopted by a private agency, my lord. We have given it to outsource it. We have not done that. So a guideline was there, guidelines preparation for results of the examination, so and so. Now, my lord, kindly relevant is page 16 down below. B, it said, though written test was held in 120 marks, we'll take it as 70%, 70, my lord, weightage, 70%, read group discussion 10%, and interview 20%. It was only weightage. My lord. There no change of marks and criteria and all. Weightage, 120 was taken to be out of 70. There was no change. Was taken to be out of 170. We have not changed it as such. That is the thing, my lord. Only weightage was given 70%, 10% to make it 100%.
Hmm.
So that way, my lord, after the change, he got 0.5 less. Otherwise, my lord, both were same,
Hmm.
0.5. And this scheme was not challenged. That is one. The person selected were not challenged, appointed, not made a party, my lord. They were not
Selected person was not made a party.
Not at all. No, none.
All right, read the judgment then. What is the
My lord, will kindly.
flaw in the judgment? Let us, know. What is the legality?
My lord, may I read from the beginning? It's only 3-page judgment. I'll read it from the beginning.
Wherever you want.
Paragraph 3.
Hmm.
Advertisement provided that selection process would consist of a written test, group discussion, and interview.
Hmm.
It was also provided in the written test will be held in 2 parts. Part 1 would be 60-mark multiple choice questions, relevant technical discipline. Part 2, 60 multiple choice questions on general aptitude, comprising reasoning, data analysis, computer awareness, general awareness, current affairs. The candidates qualified in the written test, group discussion, interview would be shortlisted candidates for the purpose of appointment. From the affidavit in opposition filed with the respondent FCI, the written test was conducted in 120 marks, group discussion 10 marks, and interview 20 marks, total 150. The instant
The problem is, Mr. Roy,
it was not.
when you fix the ratio, the percentage for group discussion and interview remains the same.
Same.
But you reduce it for the written examination.
Written in order to make it 100%. That's the only minute. And that were not changed at all. We fixed the criteria 10% for interview, 20% for group discussion.
Hmm.
The instant repetition is being
But
preferred.
because of reduction of the marks in the written test, he has been put at a disadvantage. That is the problem.
48 marks.
No, my lord. In fact, both him and the so-and-so became same. Became same marks. It's not he was, my lord,
Same means what?
same is if it is, my lord, before the conversion,
Huh.
the total marks in written test, he secured 27.99.
Who?
The petitioner secured
Is it
62.5.
the petitioner secured
62.5,
62.5, yes.
and the person, he's not made party. He said he also secured 62.5.
How many posts were there?
The polls maybe,
So the last selected would have to be implemented as a party. What do
he
you
was
say,
not made party.
gentlemen? What do you say? You have not implemented the last candidate who, as per you, was given the undue benefit. You have not implemented him as a party.
Yes, my lord. When we filed the writ petition initially, it would not be able to know about it.
Then there's no question of interfering in his selection.
Subsequently.
There are a
after
fixed
con-
number of posts. You did not implement the last selected candidate as a party. You have to be non-suited on that ground only.
What is happened actually, my
What
lord,
would be the effect of your writ petition being allowed? Either there is no direction to create a supernumerary post. So one post would have to be vacated for you.
there are 15 posts were advertised.
So the last candidate, you and the last candidate who has been selected, they were neck to neck,
Yes, my lord.
right? So that candidate not having been implemented, what kind of relief can be given to you? Tell us.
Yes, my lord.
On that very ground, what is your writ about? Is writ, what is this? That is in another case. The writ petition, this arises out of judgment in writ petition 5-3. Okay, okay. That original file has been attached.
WBC 5236.
That original file has been attached. That is why the confusion. Then you have not implemented the last selected candidate. You can't get any relief at all. And then one more thing, they have done it uniformly. They have not isolated you for rationalization of the
Throughout
marks.
the country, same procedure.
Same procedure was adopted in that.
Petitioner and respondent secured same marks, my lord. But only to deprive me, that conversion method has been applied, my lord.
This was a
Subsequent-
process. They say it was adopted in the whole of the country.
No, my lord, that process has been adopted after the advertisement publication.
Rationalization, scaling, these are things which Supreme Court has approved.
But subsequently, as it was not in the advertisement, that's why I am objecting, my lord.
Anyhow, but
You have secured same marks.
you can't get relief because that post is held by a candidate selected who is not implemented as a party. On that ground alone, your writ has to go. Your relief has to be denied.
at least one chance may be given, my lord.
For what
I-
purpose?
For impeding the party.
No, no, nothing doing now in rate appeal.
Because, my lord, as we have secured, my lord, he will be deprived of, my lord, in the year 2009 itself, my lord.
Absolutely. And you have to say anything on merits, you may address the court. If you have to say anything on merits, address the
My
court on
lord,
that.
on merit ground is that, my lord, rule of game has been changed, as you are also earlier observed it. That is correct, my lord.
All
But
right, that
rule of
we
game,
will,
because, my lord, in the advertisement, that clause was not there.
we'll
That
deal with that.
Method was not applied, my lord.
We will deal.
That was not mentioned.
All right.
And-
Okay.
And I have secured 48 marks, he has secured 47 marks, my lord.
Mm,
That is also lesser, my lord.
mm.
But subsequently, they have converted only to deprive that, as you also earlier observed, my lord, and the first time, my lord, because written test, I have secured more marks, but that conversion method has been applied.
But then it is,
subsequently.
when it is a decision taken across the country for
Yes, my lord.
everyone uniformly, then how can you, a single person, claim that you have been isolated and targeted? That claim is not sustainable
But
because.
he has to be considered, my lord, in the
All
subsequent
right,
post
but
also, my
he
lord.
could have been considered had he implemented the last candidate as a party. If you succeed or this order is executed, that candidate goes out of service.
Well, at present, earlier occasion, my lord, I did not have any objection against the last
Then
candidate.
you otherwise also could not have
Subsequently-
got relief, sir. There were 15 posts, all posts are filled in. Then what relief do you get?
Because we applied for RTI information, thereafter they have sent some fake reply, my lord. And we have also
All
filed
right,
reply
we-
also, my lord.
We'll see, we'll decide the matter. Thank you. We'll pass the order.
Deep reply.
Yes, next.
Well, in the single judge order, my lord, honorable single judge order, there was one observation was also there, my lord. To, my lord, regarding that, my lord, issue, my lord. A more equitable non-equitable method reducing the total marks have been, my lord, there.
Last signature just my lord, suggested a better scheme.
Yes, my lord.
That will not. cannot be-
Beyond the scope, could not have done.
Obligation.
Okay, very well.
My lord, my apologies, my lord, item number 10, I could not reach my lord.
Item number,
10, my lord, rate appeal by state, my lord.
that is adjourned already.
My lord.
It was called out, it has been adjourned.
I'm sorry, my lord.
Item number 2,
Attendance, mark attendance of Mr. Goswami in that. Mr. Goswami for this, for appellant, list after 1 week.
Obliged, my lord.
Maybe Mr. Lordship, also it's an apology prayer, your lordship. Actually, Mr. R.K.D. Chaudhary, he had to leave out of station, your lordship. And he requested me to appear in the matter taken adjournment.
Deputy SGM, Mr. Chaudhary is not available today. Re-notify. Now this will continue every second, third day, it will have to repeat it.
Lordship, on
Short issue, my lord.
List on
Monday,
Monday.
Monday, lordship. Much obliged.
We're trying to streamline all old matters.
Lordship,
They
this is
should
better.
come
I
up.
appreciate that.
We are there, my lord.
Yeah,
Much obliged.
item number 4,
Monday. na. Mhm.
My lord, this is a rate appeal regarding provincialization of teachers
Hmm.
and its effective date. And what happened, my lord, the appellant was the assistant teacher in Shivsagar district.
Hmm.
Thereafter, in the year 2011, and.
Mr. Mazumdar, is it not a case of gross discrimination?
My lord,
You have non-suited her on the ground that thereafter the rules were quashed. How many people were appointed under the rules as they stood before the judgment was rendered?
my lord, two things. my
How,
lord.
how many people services were provincialized under those existing? Have they been ousted?
They have not been ousted on their.
Then there was a crystallized order in her favor.
There is a judgment in favor of, there is a judgment, judgment by this honorable division bench, my lord, saying that,
Chandan Kumar Niyog.
my lord, no, thereafter, in 2019, a judgment came that when the, act itself was set aside, the only course open is to consider under the 2017 act. That was what was,
Her consideration was already done before the act was set aside, sir. That is the question. She had a crystallized order in her favor before the court set aside that act. So why she should not get the fruits of that order? That is what we are not asking you to consider it now. That consideration is already done. It is a declaration that she is entitled. Question here is, by a ex post facto quashing of the act, whether that right will be washed off.
My lord, that is what was held in the judgment of 2019, my lord.
Let's see.
My lord,
Where is that
is
judgment? Let's see.
W.
Was it a case wherein the order had already been passed? 2019. Here she has an order in her favor of 2015.
Well,
You're not having the file.
My lord, I'll just go for because I was given the information.
Day before yesterday, your plea was that these cases have come up suddenly.
Yes, ma'am.
Now they are in regular list.
They are in the regular list.
Then
We are pressing.
you see this case, you see the judgment itself. There is an order already in her favor. 2015, your director passes an order that Gopal Borgoin was wrongly provincialized. He has been ousted, and on in writ petition number 3329,
Yes.
public 14, the order was passed to consider.
Yes, ma'am.
The director secondary education passed order dated 9/3/15. Why that order should not be enforced?
Well, then that was challenged by Gopal Borgohain.
Then there was no stay.
that is correct.
Well, this is what I was saying. Well, this Punavati Brahma case, well, it says so. Well, that if the provincialization was not done till the point of time, read appeal number 283 of 2018.
Let's see that judgment, please. Are you having, Mr.? Are you having that judgment?
No, actually, I have the review petition. Actually, when the
It was there.
initial 2011 act was set aside, thereafter a review was there when single bench passed the judgment that those who were already appointed or order was passed, they may continue.
Which is that order? Let's see. Let's review in division bench.
Yes.
Let's see.
No, there was a review thereafter. That was in 2016. 17 Act came on.
Yes.
Considering the 17 Act, this division bench, my lord, to my knowledge, has held in 2019.
Question here is,
Not be given.
question again here is crystallized rights. Whether they can be effaced by subsequent development.
That is an issue which is pending before this honorable court in other writ appeals, my lord. One filed by the Department of Higher Education, my lord.
Which judge, let's see, number. Which is that review order? Pass it on.
State process Dilip Das. This is the review order.
This is a division bench order
What is her age now? Has she superannuated?
already.
Already. Then what relief can be given?
The financial amount, obviously. And my lord, in the meantime, as per the order date 13/5/2019 in this writ appeal, I was given the chance, the pendency of this appeal shall not be treated as an impediment by the respondent for implementation
Just
of
hold
the
on, hold
benefit.
on.
And thereafter, I have been already provincialized as per order dated.
Services had been provincialized.
Yes.
Which is the order?
My lord.
Let's see.
But
if
with
that has
effect from
been done-
2017.
Oh, provincialization is already done, then what is the problem?
My lord, he wants the provincialization from 2000.
That has to come, that
and
that
we have
order
done
of
it from-
2015. That has to be given effect to.
Or she could kindly have that writ appeal order, my lord.
My lord, third page.
Punavati Brahmana.
Even though
Punavati Brahmana.
provincialization was done as per, since with effect from 2017, till now, the financial benefits has not been given to me. And although there is a order of this honorable court of 2019 saying that no impediment shall be done if the non-disputed amount is given to me.
Which
As
is
per
that-
order,
Which is that order? In contempt?
no, in this writ appeal. Order dated 2019. my lord.
Then I will give.
There is the order.
Order dated?
My lord,
Mazumdar, that situation is entirely different.
13
Her provincialization has already been done. So now the issue is, what will be the effective date?
That is
The
Wrongful deprivation
the
or the date of entitlement.
Rana Singhal Judge had required us to do it from under the 2017 Act. We have done it from 5.
No, you have done it under the old act.
No, but I have done it under the new Act. No,
My lord, kindly come to order number 13th May 2019 in the writ appeal.
Just hold on. 13th May.
Yes, 2019.
Let's see.
Last para. May I read, my lord? 13th May 2019. In the writ appeal. This writ appeal. The pendency of this appeal shall not be treated as an impediment.
Please pass the order of provincialization.
Thereafter, they have
Just,
This is the order of provincialization. I've just handed the single.
no, this is not he has an order of 2017. You need to place everything on record, Mr. Council. What are you doing?
A subsequent development actually.
No, the earlier order, you had passed it on page number 3. You're saying.
While the order was passed by the director after the second writ petition.
When did this 2017 act come into force, Mr. Mazumdar?
The provincializations were done with effect from 5/5/2017. With
Under
effect
the
from
new act.
5/5 Under the new act. For
So
everybody.
this is also with the effect from 5/5/17.
Yes.
Purnamati Brahma, what is the order?
My lord, I'm obliged. Their lordship would like to have
My only question is the effective date, not because
No.
para 9.
Just.
and that is why I paid earlier in that year 2019 to give me the non-disputed amount. That is 2000 since 2017. And as per that order, the provincialization order was passed.
Para 9, my lord.
You have to, gentlemen, you have to tell us why this judgment will not come into your way. Maybe from 5/5/2017, the financial benefits can be given.
My lord, in that case, kindly
I'll read this judgment.
My lord.
Para 9. Yeah, that takes care of the review order also.
my lord, but there is a slight difference between this and my,
What difference?
yes. Kindly come to page 31
Hmm.
of the read appeal. And
Yes.
it is the letter of the headmistress which itself shows that there is a error. There was a error.
31.
Yes. Page 31, annexure 1.
Hmm.
Issued by the headmistress of that concerned school. The second.
We understand.
I am coming to
Huh.
now. Now thereafter, I have filed one writ petition and kindly come to page number 38.
Hmm.
And here, my lord, last from relevant portion 39,
Hmm.
last para.
Yeah.
In interim provincialization of service of Gopal Burar Guhai of this and that school should not be granted. Pendency
We
of this case
understand,
shall
we
not be,
understand.
however, be a bar. So interim was there. Thereafter, the matter was forwarded to the director at page number 41.
Hmm.
And after this, the director passed an speaking order against me. Thereafter, I again challenged this order before this honorable court, and on the first day itself, again, stay order was passed. So stay order is since 2013.
The order is against provincialization of Gopal Burgoyne. Yes. But your services were never provincialized. So by effect of this order, which just now Mr. Mazumdar has cited, Purnamati Brahma,
My lord.
how your services can be retrospectively provincialized?
Because in this case, no, the continuancy was not there. The party was
The writ
Not a
petition-
question of continuance, gentlemen. The court says, notwithstanding the review order,
Right.
the fact remains that an order which has been, the act which has been struck down, how an action can be directed to be taken under that act retrospectively by the court? That is the question. Yes, maybe you may have been deprived of certain benefits,
My lord.
but the fact remains that there is no provincialization, there is no provincialization. Maybe you need better preparation. Take some guidance from seniors and come back.
Kindly come to page number 12 for the time being. Because it is the order. It is the year of 2014, not 17. Annexure 12. Last para, the order dated this would not have been passed, the order dated this and staying.
But
order-
that is again, gentlemen, regarding the provincialization of services of Gopal Burgoyne.
My
We
lord.
understand. But when were your services provincialized? Your recommendation is in 2015,
That is
but it was never acted upon.
Annexure 14.
Yes,
Yes, in the year 2015.
but that was never acted upon. And while that was order was still there in existence, the order came in Purna Niyog, Chandana Niyog, quashing the act. So
And the single bench rightly observed that part also, that the department has sit over my.
yes,
For the
true.
whole-
So file a suit for damages. That is the only way out now. That is the only way out. Can we give retrospectively you the benefits of by this order? Can we give you the benefits retrospectively in an act which is no longer in existence? Ask him to consult some seniors and come back.
My lord. my lord.
There is some merit in your arguments, but whether the court can come to your assistance now. Seek some guidance.
My lord, my lord.
And counsel for the plaintiff.
There is another judgment, Lordships and Justice Sham, following this, again rejecting us very similar way, that I could not just trace back now, but this was followed again in
Hmm.
2023.
That is the whole problem, my lord. The department sits over all the time.
Yes.
And the departments,
To take your guidance,
My lord.
guidance from some senior, good
My lord.
senior, and then come back.
my lord, my
We are
lord,
giving you the opportunity.
my lord.
We are not
my lord,
ousting you right now.
my lord.
As paid by counsel for the appellant, list after 2 weeks.
Obliged.
Obliged.
ये जब- ये अंदर रखो। And read this. Yeah.
My lord, may I pray for just one thing? Although the provincialization order was passed in the year 2021, but since then, the financial benefit has not
Yes,
been given.
My lord, I'll
Uh,
look at it, sir. If
they
there
In
are
the
saying
meantime,
that
comma,
is not given.
the benefits flowing from the order of provincialization dated so and so shall forthwith be released to the appellant.
If not released. If not released.
If not released, comma, shall forthwith be released
My
to
lord.
the appellant.
Obliged.
Item number 5,
Go to the office of Mr. Chaudhary. He will offer you a cup of coffee and guide you also. He needs a little bit of guidance. There's some merit in this argument. Yes.
My lord, here I am appearing for all the respondents, my lord.
Mr. Chaudhary, your matter is called out. Item number 5, you are not briefed now.
My judicial says, my lord, these matters were taken away from them. We will no longer.
Otherwise also there doesn't appear to be anything. It was supply without any order.
তুমি reservation বলতে চিন্তা করছো, what do we do? My learned friend is obsessed with those reservation matters. I said long.
Well, and then we'll say none present, none appears for the appellants. The appeal is dismissed for want of prosecution.
daily list for hearing.
It's a remarkable case, otherwise, Mr. Chaudhary, that respondent number 5, that officer, he had the gall to place an order without there being any approval from the government. 6 crore rupees. That's really fantastic. And we are surprised that there is no prosecution of that man. He should have been prosecuted.
Few things are in very bad shape, my lord. Especially this project. There is no Director General of Prosecution in our state, my lord.
I am told, and that's really shocking. Now, there in Rajasthan, there is a judicial officer, there, grade 1 judicial
Actually,
officer.
my lord, in Assam, there was a time, there was serious law and order problem.
That's
So police were more onto, my lord, law and order, than
Law and order.
normal policing. From then, my lord, this trend has started. I think government must address that one. It's not an, objection,
This is a stage evolutionary kind of thing which should come in, yes.
Daily list for hearing, item 26 and 27.
Yes. Rabiul Haq.
My lord, before I start my argument, I would like to point out one more aspect, my lord.
You just please
Lordship,
recapitulate
this
what
is
you
a
got.
matter from the Pollution Control Board, where the appellant before lordship, he is a postgraduate. Therefore, my lord, in terms of the regulation, an order was passed in his favor by the chairman, saying that he will become AES from a particular date, then about next rank from a particular date. That was challenged before the learned single judge. and that
Chairman
was-
in his own individual capacity without any approval
Yes,
from the.
that is, anyway, that's the case, my lord. Now I find, my lord, it's correct. No, there's nothing wrong in it.
Okay.
I'll place from the regulation.
Very good.
Now, meanwhile, two development has taken place, my lord. Number one, the other appellant, Manoj Borua, because he doesn't have postgraduate, there are two appeals, my lord. He has been,
Just hold on.
Ah.
Which appeal? I mean, Rabiul Haq has filed two appeals.
no,
Yeah.
yes.
Wherein
There
there is
are
one
two-
respondent, Manoj Barua.
Manoj
In
Borua,
one appeal, there is a respondent who is
Hitesh Sharma.
Hitesh Sharma.
Ah.
Yes.
Now, my lord, as far as Manoj Borua is concerned, the board has demoted him because he doesn't have degree.
Okay.
And my lord, as far as Hiten Sharma is concerned, in the 100 meeting of the, my lord, 100 kiman asle? Huh? 104th meeting of the board, my lord, even his, my lord, degree has been not been recognized. Therefore, as a matter of fact, he, my lord, he is not having a postgraduate degree naturally from day one.
So are these,
Now, therefore, my lord, what had happened in the meantime, when both of them were, my lord, promoted, I filed another two writ petitions. Those are pending.
okay,
That is WPC 5061 of.
regarding their not having the requisite
Yes,
qualification.
and therefore giving them promotion.
So would you like to, for us to wait for the outcome of those writ petitions?
No, my lord, what I will say, if all the matters are taken together, it will
The
be.
issue is that one right of appeal will go. We'll call the writ petitions. We don't have, but subject to both sides agreeing.
My lord, I have no problem, subject to what my learned friend
What do you
says.
say?
In the other, my lord, regarding the demotion of Manoj Borua, he has already filed a writ petition before this honorable court, and some post has been directed to remain vacant. And I am
So,
not the counsel in that, my lord, writ petition, some other councils are appealing, so I cannot agree to that, my lord. Since this appeal is pending before.
But
your
my lord,
lordship will take up
this
appeal.
writ petition, he is there, my lord.
Yeah, this is, I am here, my lord.
regarding writ
otherwise-
petition filed by
Yes.
the
Manoj
Rabiul
Borua-
Haq, you are there.
Yes, yes.
So for that, what do you say?
5061, both of them are party, my learned friend is representing.
I am there, but one more is.
The other writ petition, let it go on. What do you say about this writ petition being heard together? Because it will have a bearing,
Yes.
direct bearing, whatever the fate of that writ petition is. That if you are disqualified, then obviously he gets a chance.
But the thing is that, my lord, there will, in any case, my lord, a forum will be lost, my lord, in any event, my lord. The right to appeal will go, my lord.
Then let's wait for the outcome of those writ petitions, Mr. Shah. What else?
Otherwise, my lord, since this, otherwise, my lord, I'll like to place before your lordship that though this issue is not here, my lord, that MSc degree would not have made applicable in case of Manoj Borua, my lord, from the regulations itself.
Well, whatever if that court is seized of that matter, then let the matter be decided. What
No,
else?
most importantly, my lord, board having realized that he doesn't have a PGNC
Then-
requirement, he has been demoted.
Either you bring those documents on record then in this writ appeal.
Okay.
Then we can consider
my lord,
those
what I'll
documents
do, I'll-
independently of those writ
I'll
petitions. even.
file an additional affidavit,
Well-
bringing on record all that.
Then Mr. Chair Counsel, Mr. Chaudhary submits that
Ek hafta time
in the intervening period during pendency of this writ appeal, certain important new developments have taken place, and that he is desirous of bringing the same on record through an additional affidavit.
But
in view of the
1 week
above-
time may be given.
In view of the above submission, the matter is released from parted category to be re-notified for hearing after 1 week.
Deeply.
The requisite affidavit be filed in the meantime.
Item number 28.
My lord, before my friend starts, I want to bring one small issue, my lord. Before your lordship.
The judgment of the earlier.
No, not that. My lord, here, this respond number 3, my lord. The nodal department of this autonomous council, WPT and BC, my lord. What happened, my lord? I am just placing a notification of 8 June 2022.
Just hold on. Respond number 3.
Respond number 3, my lord.
Commissioner and Secretary to the Department of Plain Tribes.
Yes, my lord.
Yes.
What happened, my lord? In June 2022, this department has been bifurcated into 2, and this doesn't exist as of today. As of today, there is no WPTBC department in Assam. What happened in June 8/22, Tribal Affairs Plains, a new department has been formed, and my lord, Social Justice and Empowerment, they took away the other part of the department. So, my lord, unless Tribal Affairs Plains is made a party, implemented as a party, my lord, we have to get the records also and some instructions from the department. Being they are not a party in this matter, we are facing some difficulty.
Yes, Mr. Chairman.
They have to, my lord. That is
They
my,
have to
my
plead, yes.
We'll file an application to implement.
And then Standing Council, Mr. Your good name, please.
Arthur, my lord.
Others points out that the respond number 3. Department of Welfare of Plain Tribes and Backward Classes does no longer exist. That has been dissolved and has been bifurcated into 3 different departments. In view of this development, the petitioners will be required to implead Department of Tribal Affairs
Tribal Affairs Plains.
On my oral request, your lordships may. implement-
as a party respondent. You will have to file the amended cost.
Very
item.
well, I'll do
Party respondent in the writ appeal. On the submission of Mr. Dhar, the taking note of the above submission of Mr. Dhar, the Department of Tribal Affairs within bracket plain is impleaded as a party respondent in the writ petition. Amended cost title will be furnished, submitted within 3 days. Mr. Dhar further submit that he is desirous of seeking instructions as well as records for assisting the court in this matter. Re-notify on.
Any date after 4 weeks, my lord, it will take some time.
Re-notify after 4 weeks. The writ petition of 2015, what is the controversy
My lord,
basically?
it's a challenge, my lords, to the Rabha Assam Autonomous Council Act, my lords,
On the ground?
1995, my lords. The challenge is, my lords, on the constitutional authority, my lords. Namely that, my lords, insofar as tribal areas are concerned, my lords, under Article 244(2), the power is that of the parliament, my lords,
So would the Union of India not be required to be implemented as a party?
Definitely, yes.
Then Mr. A. Chaudhary, senior advocate, submits that in view of the nature of relief sought in this writ petition, it would be essential to implement the Union of India as a party respondent in the writ petition. Needful application be filed, requisite application be filed within by next date, list up to 4 weeks.
Grateful, my lord.
Deeply. Maybe you will be required to make amendments in the writ petition also then. After impleading the Union of India, the tenor of pleadings may change.
Let me.
You'll have to rethink everything.
I'll take steps, my lord. I'm grateful.
Item number 29 to 30.
May I please, my lord? My lord, there are 2 writ appeals before my lord, one by the private respondent in the writ petition and the other by the Assam Public Service Commission. My lord,
Who
this.
represents the commission?
My lord, I've said he's coming, my lord. He is coming.
Who's there?
My lord, this is with regard to the Assam Combined Competitive Examination of 2013.
We'd like to know who is appearing for the commission.
Mr. Pongos, she is there. She's an appellant.
Are you ready?
I'll.
So now find out before you use your energy, whether Ms. Datta will be arguing the matter or not. Find out.
The argument, Kogan, he will be, my lord.
All right, then let's know.
My lord, the issue here, if I may just point out, my lord, there is a combined competitive examination held every year by the APSC. They have their own rules for that. In that examination, my lord, it's like the UPSC conducting the IAS examination.
Right.
Therein, my lord, there are around 11 services, 11 services, my lord. Then when the forms are being filled up, when we filled up the main forms, my lord, we have to give an option as to the the number of services, as to the services which we prefer.
Preference, order of
Preference.
preference.
And the final, my lord, merit list is made by reckoning this preference, my lord. Now, what had happened in this case, the petitioner before my lord, the appellant before my lord, had secured only 832 marks. Whereas the private respondent number 1, the writ petitioner, had secured 879 marks. But my lord, the appellant before my lord had given her preference for APS as serial number 2.
Right.
Whereas the other one, she had given a very low preference,
For APS,
APS,
police services.
police services.
Right.
Now, my lord, first they take up the ACS, the preferences are taken, and then they go to the merit, and then they fill up. Then they come to my lord, serial number 2, APS, merit position
Preferences.
given, and she was, my lord, there was a reservation
So
for
irrespective of the merit, if you have not given a preference, you will be treated against the post preferred,
preferred. one.
selected. Right.
That's the underlying factor. Now, what had happened, my lord? The writ petitioner came up before this honorable court saying that how can you give importance to that preference? Preference would be when two persons are equal, then only the preference would come.
Right.
That is, my lord, in the normal sense. When you are, my lord, making a selection for one service or one post.
Right.
Here, my lord, it's different category of post. The honorable single judge, my lord, went on that line that preference can only come in when both things are equal. And she said that I having scored more marks than the petitioner, than the appellant.
So she
I should have
said
been-
that the selection should go as per merit.
Merit
And the preferences should be ignored.
ignored, my lord. And my lord, here the question is, my lord, whether how to, my lord, give importance to
What
the.
is the status of service?
I joined, my lord, on 2015. Then, my lord, I completed my trainings. I think I've got my promotions also.
One interjection, Lordship. On the day the writ petition was moved and also in the writ appeal when it was admitted, one post, it was ordered to put one post back.
Correct.
In APS. And what is the writ petitioner serving as now?
No, I could not join, Lordship.
She could not.
Could not even join.
No, my lord. My lord, on the
So,
day
on the post, otherwise she would have got as per her preference. She did not join.
my lord,
No,
even
I
if today
did
my
not-
lord dismisses my writ petition, if this appeal is dismissed, still she will not get it because, my lord, above her, there are two other ladies, my lord.
In APS.
APS, not my lord, in the general, because if the preference
In
thing
the
is
general merit.
general merit, there are two others, my lord. She'll still not get it, my lord.
तो ये तो वो वाली कहावत हो गई, हम तो डूबेंगे ही सनम। तुमको भी ले डूबेंगे।
तुमको ले डूबेंगे। 87 no, no,
So, what relief will the respondent get? What relief she will get now?
Lordship, I'll be relying on that Lordship, vigilante was dormant was there. Law help them, we rush to the court at the first instance, not we sits idly at his home. I rush to the court, so I should get the relief, Lordship.
My lord, on the day the interim orders were passed, the appointments had already taken place. So that interim order, my lord,
That is why you have completed your service of 8 years by now.
lordship,
is supposed to,
with promotion, my lord.
With promotion.
I think she's an additional SP now.
But that one post is still lying
No,
vacant.
it's not there. It was brought on record by the state. That post is already gone, my lord. That post has already, my lord, been filled up. There is not there, my lord.
Alright. So, how would you propose to proceed? Let us see.
My lord, the.
This kind of controversy must have come in some
Yes,
selection of
yes, yes,
UPSC.
Supreme Court, my lord, 87, that ekdam direct on the point case, my lord. 87 supply Supreme Court cases, 371.
374.
371, my lord.
371.
Lordship,
Yes.
copies have been given.
MVS Murthy.
MTS Murthy, my lord.
MVVS Murthy, yes.
My lord would have the first paragraph
There is
2, my
one
lord, just
judgment probably your associate can find out. Probably in the last part of 2022, we considered in Rajasthan, that was a selection in aims. And preference was for the purpose of place of posting.
lordship.
That controversy we have decided in this very light, that once preference is given, you can't make the postings on the basis of merit.
Lordship. And that, my lord, would find the exact thing here, my lord.
Yeah, let's see.
My lord, I'll just give the facts, my lord, para 2. The Union of India has carried this appeal against the decision of the Central Administrative Tribunal at Patna. The respondent took civil service examination conducted by the Union Public Service Commission in the year 1983, held on the basis of the notification dated 18/12/82. The civil service examination is a combined one for several services, including so-and-so, so-and-so, so-and-so. He, in his application form against column number 22, which required information about services post in order of preference, mentioned his preference for Indian Administrative Service only. The results of the examination were published on so-and-so on the basis of the written examination. Final results following Viva Voce test were published on 25/5/1984. And the respondent was placed in the 280th position in the final merit list. There is no dispute on the basis of the position secured by him. He was not entitled to be recruited to the Indian Administrative Service, the service of his choice. On 29/5/84, he informed the Public Service Commission and also the ministry that he was not aware as to the implications of indicating the preference for various services and stated, "This mistake on my part please be condoned and the following order of preference may kindly be accepted." The respondent was intimated on August 14, 1984 by the central government that he was being considered for appointment to the Indian Police Service, a Group A, Central Service Group A, subject to availability of vacancies in those services, taking into account his ranking in the merit list and preference for services. He was advised to proceed for foundational course training at Mussoorie in case he was willing to consider for appointment. As indicated, the respondent did not join the training course but sat for the civil service examination 1984, but was not successful in the administrative service or the so-and-so. In 1985, February, the respondent received an offer for appointment on the basis of 1983 examination to the Central Information Service Group A. Thereupon, he represented his claim and maintained that he was entitled for appointment to the Indian Police Service in consideration of the fact that the last person offered such rank service had rank 291 in the merit list of so-and-so. The respondent was communicated by an order dated so-and-so rejecting his request. The Central Administrative Tribunal was moved for quashing the order and for a direction to the central government to give respondent appointment to the Indian Police Service. The tribunal examined the claim.
Come to para 4. Tribunal's judgment was more on equity.
Equity, my lord, then my lord, para 5.
4.
4, my lord. We have heard so-and-so, so-and-so. There is no dispute that it is open to a candidate to compete for one or more services posed by specifying his order of preference. When taking the Central Civil Service examination, column 22 of the application form makes provision for communicating of such preference. It is not in dispute that at the relevant time, the order of the preference could be altered within 30 days of the result of the written part of the examination, and a request for alteration in the order of preference in the manner indicated above could be considered by the so-and-so if the request was received before finalization of the results of the services. An appropriate ministry was satisfied that undue hardship would be caused otherwise. The procedure has been changed subsequently, but that is not material for this appeal. Indisputably, the respondent confined his preference only to the Indian Administrative Service. The note appearing before column 22 in the application form reads as, in respect of services post not covered by the entries above, it will be assumed that you will have an equal preference for those services post. You will therefore be considered for any of those services if you cannot be allotted to the services of your choice. Now, my lord, the real meaning of this note appears to us that if preferences given by the candidates are not available to be accommodated, on the basis of the results of the candidate's preference in the selection examination, instead of being rejected, he would be available to be considered for the other service. As already pointed out, the civil service examination is a combined examination for several services, and a vacancy is not available within the field of the candidate's choice. It is open to the central government to consider the candidate for the service. The effect of this note is not that the preference given by a candidate securing a place lower to the respondent would not be entitled to his preference because he has
These three lines conclude the issue.
been placed below the so and so. If the ranking alone is to be the test, preferences would have no
meaning.
On the other hand, the procedure that preferences are acceptable with reference to the position in the final list till vacancies in the services preferred are exhausted is the most logical one and meets the requirement of the scheme. Merely because the respondent was placed in 280th place in the merit list and someone else at 291 was being offered so and so, in keeping with his preference, would not give the respondent any cause of action. So, my lord, in this view of the matter,
How does the Leonard Civil Judge deal with this?
lordship. The judgment starts at page 78, my lord. My lord would have page 80, para 10, my lord. The facts in issue are not disputed. The petition and the respondent number 5 had taken part in so and so, conducted in pursuance of advertisement dated so and so, issued by the APSC for appointment to the post under 10 different state services. The petitioner secured 879 marks in the selection process, while the respondent number 5, me, my lord, secured 832 marks. The petitioner and the respondent number 5 both belong to scheduled caste female category. The petitioner had put Assam Police Service as a 9th option in order of preference out of the 10 services that were listed in the advertisement dated so and so. The respondent number 5, on the other hand, had made Assam Police Service as second option in the list of preference of services. The question that arises for consideration is whether merit can be sacrificed only on the account of the petitioner having made the Assam Police Service as a 9th option in order of preference as compared to the respondent number 5, putting the same as a second option in order of preference. Rule 2 of 1989 rule states as follows. A candidate shall be required to indicate in the application form for the main examination her order of preference for various services posts for which she would like to be considered for appointment in case she is recommended for appointment by the Assam Public Service Commission. This is important. Due consideration would be made at the time of making appointment on the result of the examination to the preference expressed by the candidates for various services at the time of her application. The appointment to various services will also be governed by the rules, regulation in force as applicable to the respective services at the time of appointment. My lord, now what the Honorable Single Judge referred to, the judgments, and also, my lord, if my lord comes to para 16, my lord. Para 15, my lord, he goes to, my lord, that Srinivasalu's case, that preference can be only when the other things are equal. Now the error, my lord, para 16, he refers to the, my lord, Honorable Single Judge. Or Honorable Single Judge refers to the, my lord, Assam Police Service. Rule 6.5 of the Assam Police Service 19 states as follows. The commission shall prepare a list of all candidates who have qualified in the examination in order of merit, which shall be determined in accordance with the aggregate marks obtained by each candidate. And if 2 or more candidates obtain equal marks, the candidate commission shall arrange them in order of their relative merit, which shall be determined in accordance with the general suitability of candidates to the service. List shall be forwarded to the governor to be published in the Assam Gazette. Now, my lord. A perusal of Risk 5 shows that the APSC was to prepare the list of candidates in order of merit in accordance with aggregate marks obtained by each candidate. Thus, the petitioner being more meritorious than the respondent number 5, the petitioner should have been selected over the respondent number 5 for the post under the Assam Police Service. The preference given by a candidate is only to enable them to able to join a particular service if they are deserving enough on the basis of marks secured by them. It is only when a candidate cannot be appointed to a service of her choice, first option depending on the marks secured vis-a-vis other candidates, that the candidates will have to be considered for the second or third option exercise. In the present case, the petitioner would have to be considered for Assam Police Service along with the respondent number 5 only on the basis of marks secured by them and not on the basis of preference expressed by them. Now, my lord, this reference to the
What preference did the petitioner?
ninth.
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 And was she selected on that preference?
No, madam, she did not come in. Because my preference was second. So I got that opportunity early.
APS was
One.
2.
Two.
She give any other preferences?
Yes, madam. She had
So
given other
what is the
preference.
position in
That she did not come in, madam. Because she was a reserve category candidate.
So in no other service could she secure the
No,
position?
no. Because the reservation was only for, my lord, APS.
Okay, no other
The
post.
female, no other post.
There were no reservation in other posts.
No post, madam. At that time, it was like that. And my lord, the reference to the rules of Assam Police Service at that stage is not maintainable, my lord. Because this is with regard to the manner in which the seniority would be fixed when they come into the service. And that would depend on the manner in which the list would be prepared. So this cannot, my lord, govern the APS rules, my lord, of that selection.
APS rules have been considered or no,
Yes, yes,
the Public Service Commission, that preference that is based on some set of rules,
rules, my lord, that is there at para 12, my lord, he has considered that.
he has considered it.
Para 12, 2 and 14 of 1989. Rule to division. Then, my lord,
But what he deals is at para 13,
lordship,
that the 1989 rules would be applicable only for preliminary examination.
no,
How-
my lord,
how
it's
that
for, it's
distinction
for
is
main
done.
examination also. The 1989 rules, my lord, if my lord can have the services. Services, my lord.
Okay. What is this? Para 15, para 14, what is the finding based on?
Para 14.
14 reads that smaller font.
Lordship, the advertisement dated so-and-so states that APSC would hold the preliminary examination of so-and-so for screening candidates for the main examination for recruitment to the various mentioned services in accordance with the Assam Public Services Combined Competitive Examination Rules 1989. The above clearly shows that the rule so-and-so would be made applicable to for the preliminary examination. It does not talk of 1989 rules being made applicable for main examination. Be that as it may, if the main examination of the so-and-so was to be held in accordance with so-and-so of the 1988 does not take away the merit marks secured by a candidate at the altar of preference or option exercised by the candidates. This is clearly reflected in 6F of the advertisement, which states that the candidates will be allotted cadre strictly on the basis of merit cum
Merit
preference
cum preference.
opted
Mr.
by the
Mr.
in their
Nair,
application for
if
the.
it is merit first and then preference.
My lord,
second.
will have the rules, 1989 rules. my lord.
Yes.
Paisa, is it? My lord, it's at 143. My lord is holding this
Yes.
book, my lord.
143.
143. My lord would have rule 3, my lord.
Yes.
Notwithstanding anything contained in the Assam Civil Service Rules, so and so, the Assam Taxation Service Rules, so and so, the Assam Police Service Rules, 1992,
Okay, there's a non-abstante clause.
non-obstante clause. It starts with that. And which shall hold the combined examination every year in selection, so and so, in accordance with the procedure laid down in Schedule 2. The commission shall, after the main examination, prepare a merit list of candidates, forward such list to the so and so to appoint under the respective services. Now, my lord, Schedule 2, my lord would find, if my lord can come to that clause 2 there, 3, 2 there, my lord. The services are given, my lord, at page 146. Then, my lord, 2, there is 2 twos, my lord.
Yeah.
Now 2
Candidates
below.
are required to indicate in his application form for the main examination.
Main examination, his order of preference for various services posts for which he would like to be considered for appointment in
What
case
is this
he,
clause 6F which has been referred to?
that is in the advertisement.
Let's see. So is it, is it not contrary to the rules?
That is contrary to the rules. Advertisement.
At page 17,
Lordship,
16, 6. What is 6F?
just getting that, my lord. I'm not.
Come to page 19, Mr. Nair.
Lordship,
Come to page
6F, my lord
page
would find
19.
90.
One more clause, yes. How would that clause operate? That again talks of merit cum preference. Marks thus obtained. Are you having?
No, no, no. The marks thus obtained by candidates in the main examination, so and so would determine the final ranking. Candidates will allotted to various services, keeping in view the ranks in the examination and respective preference expressed by them for the different posts.
So that.
That, my lord, if my lord reads it with the 89 rules, it would be, my lord, the preference would be taken and the 87 judgment, preference would be taken, the ranking would be seen and the allotment would be made. And that was what was done for preparation of the whole syllabus. 6 septic management.
6, very
16E.
6.
16.
Single
16 page. I'm just giving that, my lord, my lord would,
Almost Same, it is almost the same.
same, my lord, 16 F.
There seems to be one page missing actually.
More. 54, my lord, page 54. Yes, my lord, page 54.
Hmm.
My lord would see interview test F. The candidate will be allotted cadre strictly on the basis of merit cum preference opted by the candidates in their application for main examination. The wordings might not be, my lord, this, but the rule is very
The
clear,
rule is clear.
very clear.
Yes.
And finally, my lord, the honorable single judge, basing on these two analogy, my lord,
Hmm.
at para 18,
Yes.
my lord, limits it to merit. In present case, rule 65 of the so and so clearly requires that selection should be made only on the basis of merit.
That
That
is. There is a
non-obstante clause.
Notwithstanding clause.
It goes.
Notwithstanding clause is there.
So this reasoning itself, my lord, is enough, my lord, for the erroneous part, my lord.
Yes.
And my lord, if my lord can have 84 also,
84.
a page 84,
Hmm.
the first paragraph, last line, my lord. The story would have been different if the petitioner had not made any option for Assam. So, my lord, if she had made an option, if she had not made an option, it would have been the same thing. It would depend on the number of the options. This is my limited case.
Yes. APSC. You are for?
APSC, my lord, he's for the
Okay.
APSC.
Yes. Hmm.
All the argument advanced by my senior, I have adopted that argument, but I would like to just point out one thing, Lordship.
Yes.
In page 71, Lordship, in his appeal, and page 45 in my appeal, Lordship,
71.
71, Lordship.
Yes.
Lordship, there are the petitioner, Lordship, Lordship, petitioner secured 879, Lordship. Lordship got it, that chart I have mentioned, Lordship, in my affidavit. And above the petitioner, there are two other candidates, Lordship, by securing 894 and 886 marks, Lordship. So if as belonging to XC, if otherwise, Lordship, anyone has to be considered, not the petitioner, Lordship, those two candidates only, Lordship.
But what is their status? They have been,
No,
they have also not been
they have
selected.
not been selected, Lordship. Because due
Because
to
their options were different.
were different.
Options were different.
Lordship.
My lord would just read that down below, my lord would find it. The paragraph just after the, that list,
The table, yes.
it pulled it. It is also to be noted.
It is also to be noted that the claim of the petitioner that she should have been selected to any of the services under CC Act 2013 is not factually correct, since by virtue of the mark secured by her, she could not be selected under open category, and there is no reservation at all for SC category, not to speak of SC.
There was
female.
one candidate who
The service.
secured
Lordship,
988
Lordship.
and I had given a second preference.
No.
So that candidate was selected and the appellant was selected.
No,
They were the two persons.
this person.
Uh,
Because the another, there were two posts reserved for SC female only in the cadre of APS, where apart from the selected SC female candidate under dispute, another candidate being rule number so and so and opting second preference for APS was selected, who secured total 988 marks. So this is the position also.
You are, what is this document, by the way?
Lordship, this is the affidavit
Affidavit.
filed by APSC Lordship,
Okay, okay,
before the single judge.
very good.
And in paragraph 8, Lordship, we have described the detailed procedure, how the preference is applied, Lordship.
Very good.
Lordship,
Lordship may take up the writ appeal
What
72.
would you say to this situation? There are two candidates above you.
Lordship,
So otherwise also,
I have, what I have submitted
So-
earlier, Lordship, that vigilantibus, dormantibus, Lordship. Law helps them who are vigilant, who rush to the court. and-
all right, well, you are asking
Sitting
us,
idle.
you are asking us to apply or allocate the seats as per merit. So simply because only you approached, whether those two candidates will be deprived,
Then Lordship, that will be on the basis of merit.
then what relief are you getting otherwise also?
Lordship, I have a case, Lordship, I will.
Other than displacing her, what relief would you get?
Lordship, I will get relief because I have rushed to the court. Others
That
might be
doesn't
acting-
matter. The court will, so court will shut their eye to the meritless then. If we decide that the things have to go as per merit as per the APS, then the merit list has to be adhered to.
That's true, Lordship. That-
Then
let
you
them
don't get
adhere-
in otherwise also, because there are two more candidates.
Lordship,
They will have to be invited.
Lordship, what they have stated that it will be on the basis of preference, whether it is merit come preference or preference.
So
cum merit.
read the APSC rules first.
Lordship, may I-
All right, you proceed as per your own choice.
Lo-
You argue the matter as per your choice.
Lordship, can you take up the writ appeal 72 of 19 by APSC, Lordship?
Why this, all documents are there in this file?
Lordship, I will like to refer,
All right.
because I have.
That file. The other file, please. First, how do you get by MVS Murthy? That has not been considered by.
Lordship, I'll try to distinguish because in that case, he did not apply only IS, Lordship. Other was not, he has offered.
Other, you could not have applied in the reserve category. There was no reservation. So irrespective
No,
of the fact,
Lordship. That is-
you applied for the others. You applied for the others, but there was no reservation. So it is as good as you were considered in the general category for the other post. To tell us, Mr. Chakravarti, then what is the use of preference?
Lordship. No, Lordship, that is not correct because SC female Lordship will find in other category also, Lordship.
Then your grievance is not there that you have not been considered in the other categories. It's not your grievance that you have not been considered.
Now, because there was a cutoff mark for us, by virtue of that cutoff mark, I fit only to the APS, Lordship.
So
Cutoff mark was 700 and Lordship.
it is the statement of APSC in their affidavit that there was no reservation in any of the other services.
That perhaps was not made. Lordship.
Yes.
That is what they have stated on affidavit, but you know, don't dispute it. So you could not have applied in the reserve category. Your other preferences, they would be in the general category only, general seats,
Lordship.
on the
Lordship-
basis of marks secured.
Lordship, may kindly come to the rule, Lordship. That
Yes.
Lordship.
Rule 140, yes.
Rule 3, sub rule 2, Lordship.
Mm,
The commission shall, after the exam, main exam, prepare a merit list of candidate. It is not a preferential list, Lordship. It said about merit list of a candidate, forward such list to the government. It
yes.
is not a merit preferential list, Lordship. It should be the basis of merit, Lordship.
Merit after applying the preferences,
That,
that merit will not be bereft of.
that is
the
not
schedule.
implied in 3.2, Lordship. In my respective
Now come to
submission,
schedule 3.2 is not to be read in isolation.
Lordship,
The selection has to be done in as per schedule 2.
Lordship,
Schedule
schedule
2
2,
read.
Lordship.
What is the position?
Lordship, may kindly come to rule 12, Lordship then.
Yes, please.
Rule 12, Lordship. After the interview, the candidate will be arranged by the commission in order of merit
Hmm,
as disclosed by the aggregate marks.
Hmm.
Finally, award to each candidate in the main examination, written examination interview put together. And in that order, so many candidates are is found to be qualified for the commission at the examination shall be recommended for
Come
appointment.
to Rule
Up
14
to,
then.
so it said about merit list,
Rule
not
14, Rule 14.
Lordship, I'll come to road 40. Due consideration will be made at the time of making appointment on the result of
On
the
the result.
examination
So
to the
result
preference.
and appointment.
And
And then when the recommendation is to be made on to the comment,
Lordship,
then it is based on merit.
Lordship,
So-
the result will be on merit, on the ranking.
That is the recommendation. Before that, this list has to be prepared as per preference.
Lordship, may kindly come to the appendix, Lordship,
Appendix. now.
Yes.
3, Lordship,
Mm,
Subpara.
3.
mm.
Appendix 3, Lordship, the subpara,
Appendix 3.
3.
Appendix 1.
Appendix 1, serial number 3, subpara.
Yes.
Start with marks thus obtained by the candidate in the main examination,
Mm.
written part as well as interview, would determine their final ranking. Candidate will be allotted to the various services, keeping view of their ranks in the examination and respective preference.
Mm.
So rank will come first, then preference, Lordship.
Can't be. Otherwise preference becomes redundant.
Lordship, that is the scheme of the act. Escape that ranking.
Before that, you will be ignore Rule 14 then.
So
Will
Lordship
be
has
ignore Rule 14, sir.
rule for 14 only says about due consideration.
Hmm.
That's it.
So what is the otherwise,
It
what
has
is
to
due
be,
consideration?
it has to be to do the ranking also, Lordship. The merit list, it says about merit list, not preferential list, Lordship.
Very well. How do you distinguish MVVS Murthy?
So, Lordship, this MB Murthy case, Lordship, he did not opted, he only opted for IS. By
Not
virtue of this
efficient. What is
marks,
the principle laid down? What is the ratio? Read, please.
Lining, but- Yes, it's
Read para 5, you'll get the answer.
Lordship.
different owning of.
Applying against one service, that is not the issue here. The ratio is on the preference, effect of the preference given. So they could have considered you for other service, but there was no reservation.
Result.
So there was no consideration for other services.
But Lordship,
That is the problem.
in my respective service, Lordship, the scheme of the act only says about merit lists and ranking.
Otherwise, irrespective of, even if your argument is to be accepted,
Lordship.
it's an exercise in futility because there are two more candidates above you in that very category.
Lordship, they did not come to the court, so
That
that
is not relevant. If we are treating, if we are trying to apply the principle of merit, that will be applicable to all.
Lordship.
It will be distributed amongst all equally placed candidates.
Lordship.
So that if there is a general decision, your client otherwise also doesn't get the relief. There is no dispute.
But for that, she cannot be allowed to Lordship.
You are in a rate of quo warranto.
Lordship, I just, I was pointing out to the appeal, writ appeal filed by the APSC, Lordship,
Yes.
page 16E,
16E.
E, Lordship.
16, right?
Lordship has gone through clause F, but Lordship will also look into the clause D.
Page 54.
16E, Lordship. The advertisement,
Page number.
page 16E, that is what has been written, numbered in by the appeal.
It's that way only.
D, Lordship. The marks code at the interview will be added to the marks code in the written part of the main examination, and the ranking of the candidate will be determined on the basis of total marks obtained.
Right.
So where the preference part is at F, Lordship. This cell is also said about merit come preference and not preference come merit.
So the merit, the preference will be looked into. In that order of preference, the merit will be seen, whether you come in within the preference. That's how the things are. Within that category, the merit will have to be
In
seen.
my respective service, the merit
categories-
cannot, in my respective service, the merit cannot, the preference cannot overlook the merit,
Oh,
Lordship.
then what is the use of the preference? Tell us.
It's only an indication. That is what has been stated. It only indicate. The word use is Lordship only indicate.
Come to G. If the merit was to be seen, come to G. Where does merit go?
He says
Supposing the
only-
candidate secures the merit for ACS.
Lordship.
As per G, she will not be he or she will not be appointed because there is no preference. This gives an indicator preference has a more vital role to play. See, read G. Please read. Let us understand the meaning of G. You have it on 16E only.
It only says that one will be not recommended or if he has not opted for. that
Not opted
particular
for, so no preference given, no appointment irrespective of the fact that you are in merit, you are higher.
Lordship. That
What
can
does
be-
that indicate?
That can be
The supremacy is to be given to the preference. Thank you. All right.
All right, if I may just clarify one thing, the merit list on merit has to be prepared, madam. Thereafter, the preference is taken and on the basis of merit, they will come.
They can
It is
come.
not a case, madam, that.
Merit
our
is not
option
being
was there,
ignored. Yes.
Cannot be. ignored. Much obliged.
And your Lordship, the marks, difference of marks is also substantial, not minimal, Lordship.
You took that risk. You should have given a preference 1, 2, 3, 4,
That I have given, Lordship.
but you gave 9 preference to police services. That is a
She did not
problem.
want that.
The reservation was provided in only one.
Lordship.
So that is a foolhardy decision not to apply for APS. Either your client was very confident that she would score more marks so as to get in the general
Yes,
category
yes.
candidates. That is a problem. So that overconfidence did her in.
Much obliged.
Item number 34 to 49.
My lord, understand at the expense of my learned friend, this matters has been brought. My lord, the division bench of the, another division bench of the honorable court, my lord, heard to writ appeals.
Heard,
Huh. And the order has also been passed, my lord, but the certified copy has not been uploaded.
same controversy.
Same controversy.
Same
My lord, in this case, Lordship, I'll harp on item number 40.
No, before item, before item.
Has the coordinate bench
Huh.
heard the same controversy?
No,
Reserve
the coordinate bench did not hear the same controversy. The coordinate bench disposed of the appeal. And the appeal was, the order of the single judge was upheld. But Lordship,
What is the judgment? Can
yes,
you-
my lord, the sum and substance of the judgment is that,
Are you having a copy?
no, we didn't, it was dictated in open court.
So let the
The-
copy come.
Yes.
The judgment come. If it has
And
a bearing,
secondly, my lord, why should
what is
we?
the controversy in brief? Tell us.
Yes,
Yellow
there are two sets of cases, my lord.
Mm.
In one case, which my learned friend represent, there the issue is regarding, my lord, collection of quantifiable data. And in the other batch of writ petitions where I appeared in some of the cases, my lord, we say that going by the state government's own stand, including affidavit and the OMs issued from time to time, the catch-up principle has revived in as much as, my lord, consequential seniority is no longer there. Now, for a period, there was some confusion, my lord, but when OM dated 18/1/23, state government has expressly said that consequential seniority will not be available,
Not the,
not be available.
on the basis of reservation.
Yes, that means, my lord, a person getting a accelerated promotion
Hmm.
will not get consequential seniority.
Seniority.
They will get in a particular situation, that is where, my lord, there is in the promoted cadre, there is a slot for the reserve category.
Hmm.
And that seniority which they have earned by virtue of the accelerated promotion, that can be used only qua those rosters,
Roster.
not
on the
against
basis of
general
roster.
category. Yes.
Very
So, my lord, as far as the second aspect is concerned, now my argument was, my lord, earlier, my lord, lordship knows after the Virpal Singh Chauhan's case, state of Assam issued a circular in 96 saying that the general category candidate will regain the seniority. But we all know, my lord, Virpal Singh Chauhan, no law was laid down because Railway Board circular itself provided it. It was only Ajit Singh too, my lord, the law came to be clarified. So, my lord, therefore, based on Virpal Singh Chauhan's case, my lord, state of Assam issued a circular on in 96 whereby it was said the general category candidate will revive the seniority. Then, my lord, immediately after constitutional amendment, when 16(4)(a) was inserted, state came up with an OM. That was on 12/3/2022, my lord, 2002, whereby it was said the reserve category candidate will not only get accelerated promotion, they will also get consequential seniority. Now, my lord, things continued like that. Now, after the judgment in, my lord, Nagraj, when, my lord, the different dimension was given to the law of reservation, my lord, then, my lord, in the, of course, following R.K. Sabharwal also, Assam government amended the act, my lord, Reservation Act, making it post-based reservation. Earlier, it was vacancy-based. Simultaneously, my lord, immediately thereafter in 2014, 29/12/14, Assam government issued an OM where it was clearly said, my lord, that roster promotees it will not be considered for the purpose of seniority. Then, my lord, on 3/8/16, another OM was issued whereby a clause was inserted whereby it was said, if there is a reserve category candidate available for promotion, and there is a general category vacancy in the promoted cadre, a reserve category will be entitled to apply for the seat, provided he has not earned an accelerated promotion and consequential seniority. So therefore, my submission was
One relaxation only, that is the concept.
yes, yes. So, my lord, the learned single judge has now the coordinate bench has decided, my lord, that since 12/3/2002 has not been expressed.
Maybe we'll send the,
I think lordship.
send the appeals to the same bench. if they have already applied mine.
My humble submission is, my lord, it should go to, these matters should go to the single bench, my lord. Why should
No,
they
my lord.
lose their right of
But,
appeal?
I beg to differ for the simple reason, on my submission regarding item 40, your lordship, a specific
these are all
order was passed to
petitions.
bring it. My lord,
Which
what
order?
has happened
Let's see
now?
Let's see the order.
Yes.
That order has
Your
taken
lord-
into account the fact that a forum would be not.
Yes.
In fact, into your
That's not
lordship's
so, then
order,
why-
your lord-
Why should we?
No, you-
deprive the Party of a forum.
My lord, the reason was, the submission was that the Journal Singh too was violated by the Assam government, which has not been referred. And the Assam government, they made groups, which is not permissible under Journal Singh.
Whatever the single bench would be at liberty to examine everything.
Exactly,
Then we'll
It's-
send the matters back to the single bench.
yes.
My lord, your lordship will, the constitutional validity, your lordship wanted to take up because it's a matter of the division bench. There's an order of March 2023, where I submitted that since a rule is challenged, we will take up. There's a specific order of your lordship. My lord, item 70, if I may take up your lordship, item
My lord,
40.
just to take this steam out of my learned friend's argument, if at all division bench is to hear this matter, lordship will hear the matter, we have no.
Yes, my lord, and I want the lordship will decide. My lord, what has
If
happened?
this particular
Well,
bench hears the
My
matter,
lord,
my lord, we have
certain
no objection.
factual matters were not placed, which I have to place because
Okay,
the
please. don't-
Well,
don't
the
travel on
constitutional
same path.
validity matter, lordship will come to the judgment.
Just hold on.
Yes, my
It's
lord.
a very detailed order passed by Leonard Single Bench.
Yes, my lord.
Let's see.
In fact, yes, 104 is the operative part of the order, if I may read, lordship. The Roman tree starts.
But where is the precise order of?
My lord,
placing these
the
matters?
precise order is, if I may place, lordship, the clause 4 was brought in where the benefit of merit was denied to us, we approached. And the judge says you cannot be denied the benefit of merit.
Please
That-
tell us which is the order by which the matters have come up with before division bench.
My lord, the-
Order
to give a chief justice.
Specifically, I was also present, lordship saying since some division bench matters are already fixed here. That is why the single bench matters issue, but containing the same issue, we hear. Now that the division bench matters have already taken up and.
Decided.
We decide.
Yes.
Judgment reserved. Here
No,
is-
no, I was told that the order has been
Yes.
pronounced in court.
They
They
deliver.
were pronounced in court.
On board order.
Only
In
thing
fact,
has
the
not been
March order
uploaded.
to be announced.
Tell us in
Yes.
this bunch, which is the order
My lord, in
by
March,
which we have directed the.
Yes,
expedition
yes,
to
my
be
lord.
looked
on my submission, it's an order of March. Yes, sir. Where, because your lordship wanted to know that since the rule has been challenged, but what has that, my
at.
submission was that
We understand, sir.
the single judge's order was defied. Assam government did not comply with it, 6 months it waited.
Please tell us the date of the order.
Yes, in March.
We want to find out in which
Well,
file.
Well, in your lordship's order in the writ appeal 46, your lordship has passed an order.
Read the appeal.
Your lordship,
That writ appeal
which
has
were,
been heard.
before- yes, my lord, your lordship had brought in, because these matters were pending there. Your lordship was,
This court is apprised. And these are all single bench matters. This court is apprised that
Emanated from the.
in writ appeal number
46,
46 oblique
2023.
2023, coordinate division bench. An order was passed to list these writ
Yes.
petitions before the division bench for joint consideration, for analogous consideration. However, if
In view
by
of
way of
the-
a further development, the arguments, the said rate appeal has already been
yes,
heard and disposed of.
Yes.
Let the order passed by the division bench and the writ be placed for perusal of the court on the next day.
my lord,
They notify.
only I pray that since what has happened, because of the impugn OM, what they have done, the offending clauses
We
were
are not
brought in.
passing any effective order right
But
now.
lordship, can I pray for a early date? Because now promotions are being
Get the
effective.
order here. When will?
My lord,
when will-
my entire case is WPC 363. Can I not ask for a disposal of my 363 where the constitutional
Then
validity?
We will, constitutional validity.
Yes, my lord, because,
Which?
my lord, this
My lord.
item number 40, my lord.
Order to Vice. My lord, we could locate that order, my lord. This is 3/3/23.
What is the order?
Let this appeal, list this appeal along with writ appeal number 239 of 22 and WPC number 363 of 23.
Yes, this is the
So
order.
that is the only writ petition wherein the validity. is-
Yes, my lord, because
Then why other single bench matters have been tagged?
no, my lord, the single bench matters were being tagged for the simple reason, when this 363 came, the lordship passed the order.
the consequential,
Item
uh,
40, please.
the consequential promotions were affected and we came down. So, because your lordship wanted that once we pass the,
Mr. Das, unless there is a specific order, even that writ petition you have filed in single bench,
my lord,
that writ petition.
no,
you have-
that, yes, I filed it there, but when I moved this court, your lordship wanted that since the validity emanated from the writ appeal, we will consider the rule.
Only 363 we directed.
Yes,
to
yes,
that.
because I
Not
want
the other
only
writ
three.
petitions.
No, my lord, because if your lordship decides 363, that is sufficient. The other principles will apply and it will be disposed of. Because the other matters I don't know.
Let the order be.
Yeah,
placed.
lordship will take up only 363.
Let that order come first.
Yes.
List on. 29th August.
God bless. In the meantime.
Item number 50.
May I please, Lordship? Last occasion, Lordship has directed to take instruction as to whether the private owner is defaulter or not, Lordship. Or specifically is that he is defaulter, Lordship, and in terms of the rules.
Yes, madam.
Yes, Lordship, I have dropped an instruction, Lordship. Yes, he was a defaulter, Lordship, but there was interference of this honorable court, Lordship, single judge's order, Lordship, where it has been asked that settlement has to be made because he was the only highest valid bidder,
Then
Lordship.
what to do?
But
Yes,
Lordship, as per the
And-
rules, defaulter,
We are not examining the validity
Yes,
of the single
Lordship.
bench order.
But he,
If you want to challenge,
but
challenge that order.
Lordship, in the single judge, before the honorable single judge, Lordship, the government has taken this plea, Lordship, that he is defaulter, but.
Maybe,
since-
but thereafter in a separate writ petition, single bench has passed an order.
No, Lordship,
Yes,
Lordship, in this particular writ petition, Lordship.
and he has already.
Lordship,
done-
Kali-
Specific writ petition.
Lordship, may kindly peruse the page 66, Lordship.
Just hold on. Whether the fact of this defaulter was considered,
No, Lordship. Page 66, Lordship.
just hold on, hold on. You are referring to this very, madam. You are
Lordship.
referring to the very same order which is under challenge in this.
Yes, Lordship. Lordship, may.
So how a defaulter can be given the settlement, tell us?
Lordship, this was also taken care of, Lordship. Lordship, at that time, it was not properly shown, Lordship. This was there.
They have taken this ground, Lordship. Page 55, the affidavit filed by the government, Lordship. Para 8, Lordship. May I please, Lordship? May I read, Lordship? That with regard to the averments made in paragraph 8 to 11 of the writ petition, the deponent begs to state that 7 numbers of tender submitted tender papers in respect of their society for settlement of number 4 Sonai Nodi Part 2 fishery of Nagaon district. Amongst them, 3rd, 6th, and 7th highest bidder did not submit call deposit, and the 1st and 4th highest bidder did not submit call deposit for required amount. Hence, their tender papers were treated as invalid. Out of the 2 numbers of tender, Sri Ganesh Chandra Das, Secretary Sri Kuji Masmora Somway Committee Limited, 2nd highest bidder, did not submit neighbor certificate issued from the competent authority, namely concerned revenue service. Besides, the society was a defaulter of government revenue as per the observation of the tender committee. So the ground was taken by the
Who is
government,
there-
Lordship.
who is
And
there
page
for the-
66 of
who is
the
there for the private respondent?
Lordship, last time the council for a private respondent submitted that the brief was returned back. Lordship has passed order. And learned single judge has considered the paragraph 60, page 66, Lordship.
Then we'll have to put the respondent number 1 notice again. That is the problem.
Yes.
And Council Mr. Das, who was earlier representing the respondent number 1.
Not
First to the-
respondent one, Lordship, respondent 5.
MS M. Bhattacharya, yesterday is on record. Copy of the communication dated 2nd August 23, issued by the Commissioner and Secretary to the Government of Assam, Fishery Department, which affirms the fact that the respondent number
5, Lordship.
5.
Five.
Respondent number 5.
Yes, Lordship.
Uji Satra Machorma.
Yes,
Yes,
That is
Lordship.
respondent number 1 in this appeal. Respondent number 1. The Puji Satra Mashmura Sambai Samiti Limited. Respondent number 1 in this appeal. To whom the fishery settlement in question was allotted, was a defaulter to the tune of rupees 21 lakhs 71,500 during the earlier tenure of fishery.
Lordship, as per our instruction, he has already deposited 4 lakhs, Lordship, and
But that
notice has
doesn't
now
matter.
been
That-
issued.
that
Yes,
doesn't
Lordship.
change his status.
On that day,
If he was a
yes.
defaulter
Yes.
on the date of
On the
settlement,
date of
the
settlement.
settlement could not have been.
Lordship.
So why do we need to wait for that then?
Yes.
If he's not represented, if they are not represented, they are not represented. The notice has been served. All right, you argue, what is the condition by which the settlement can't be made to the,
May, kindly take up the fishery rules, Lordship.
yes, fishery rules. This fact was concealed also. But they must have given a no Bakijai certificate or a no due certificate.
Lordship,
Lordship.
clause 14, Lordship,
Clause
Yeah.
14,
page 55, Lordship.
55.
May I read, Lordship? The successful tenderer must produce valid patta or certificate copy of Jamabandi in respect of land owned by him or any other acceptable proof of his financial capacity or stability.
So Bakijai certificate, that is what it is. But no due certificate, that had to be given,
Not submitted, Lordship.
not submitted.
Yeah.
How the single judge has
Lots-
dealt with this aspect?
Page 66, Lordship.
Just hold on. 66.
Paragraph 14.
Hmm. Affidavit in opposition, this is stated.
Yes, sir.
What is the document required? The petitioner had to counter that. Where is the affidavit in reply?
This is not there, Lord.
They have not submitted. it.
So then the burden was there on them. This order has to go.
Lordship, can it be taken up tomorrow, Lordship?
Tomorrow already.
Yes, Lordship.
Let's simple list tomorrow as paid by.
Lordship.
If you can inform
Yes, Lordship.
the
I will.
day after tomorrow, Friday. Tomorrow is Friday.
It's tomorrow, Friday, Lordship.
Tuesday.
Deeply obliged, your Lord.
Tuesday as paid by MS. Pataka.
Item number 51.
Deeply obliged.
Lordship, in that case, Mr. Mazumdar is leading this case, Lordship, I am Mazumdar. Based on legs, my lord, and I have prepared a short synopsis, Lordship. It will be,
Synopsis you give when the matter is argued. For that, what is the point? Are
Yes,
you arguing the matter?
Lordship, I just point out the one issue that in this manner, in the read court order, Lordship, in the repetitions, the single judge has held that CCS is not applicable in my case. In the repetitions, I have challenged the
Then you give this synopsis once the matter is taken up for the argument. It is stated that Mr. R. Mazumdar is busy in some other matter. We notified for hearing on 24th August. Or submit.
Supplementary list, item 52 to 55.
Please, your Lordship, the councils are,
Councils are in a slumber.
it has actually come up suddenly. This matter was actually heard by Honorable Justice and petitioner.
We've seen the note, yes,
we have
seen them.
made all the facts, dictated the
Yes,
facts.
right.
The adjournments were taken and the matter couldn't be taken up.
What is the custodial period of these accused? They were on bail during trial
A few of them are on bail.
because otherwise the incident is of 2001.
Yes.
All right, we'll get the custody certificate. Let the registry shall procure custody certificate of the accused appellants from the jail concerned and place the same on record. List on. List on. Sorry, when do you want, madam?
So Jet Kamar is there.
Our item is 55, 50/2017.
Are you prepared to argue today?
No,
When do you want the matter to be taken up?
yes.
After
You are for.
After 2 weeks.
After 15 August, my lordship.
What happened? Yes,
I am from item number 52, madam.
yes. Are you ready?
Already, my lord, my senior is on his legs, my lord.
Ms. Kamar.
No, SC whispers on behalf of.
Re-notify for hearing on 24th August.
Item number 56.
Population.
Where is the learned amicus curiae?
Mr. Yes, I can.
Learned amicus, what is the evidence, madam?
No, even, we don't have the paper book. That is the difficulty. I've told my office
Public
to
prosecutor,
reconstruct.
Ms. John submit that the paper book has not been provided to her. The rest to do the needful and re-notify the appeal for hearing. 2017 appeal, you will not have.
We had, they must have missed it. They must-
Submit that, she has misplaced that part and needs short opportunity to compile the same. Re-notify after 1 week.
Fifty-seven to 59.
Is here. Your good name, please?
Vijay Saikya, my lord. My lord, what happened
Vijay
there?
Saikya.
There.
You are amicus.
No, my lord.
No, representing, all right. What do you say? Are you ready?
My lord, almost my lord, ready.
Almost. In a criminal appeal, there is no almost. Either it is this way, that way. Be sure.
My lord, there are two appeals, my lord. One from the jail appeal, my lord, and the regular appeal.
They'll appeal, it will be consolidated. Don't worry about the two appeals.
My lord,
Yes.
What about Raju Satnami, who is representing?
I am.
This Vijita Sharma, oh, you are there, no?
And
Amicus curiae, my lord,
for
Vijita Sharma,
Saju Satnami also you are there.
my lord.
So there are two accused.
Yes.
There are more. There are more accused.
More
three
accused,
others.
Huh.
What is, all right, tell us briefly, what is the case?
Case is, my lord, there is no eyewitness in the case, my lord.
Circumstantial evidence.
Circumstantial evidence.
What are the circumstances?
Only one circumstantial evidence, my lord, that is the evidence of doctor, my lord.
Doctor.
Yes, my lord.
So it is a
Since the-
case of murder of wife
Since the, my lord, incident happened in the hospital itself, my lord.
in the hospital.
My lord, inside the hospital.
And what is the status of the relationship of the accused with the deceased?
My lord, there is no relation, my lord. No. No. Like initially what are the put
At about 7:30 AM, Raju Satnami had my mother with down in front of nurse and doctor
Yes,
while my mother was undergoing treatment.
yes,
So, well, the doctor and the nurse, they must have given evidence.
my lord.
Let us see the evidence.
In the paper book, page 15, my lord, evidence of the doctor, my lord.
Dr. Kalyan Barua.
Yes, ma'am. May I read the mail? I am presently serving as senior medical.
So
and
it's a
health-
last scene. It's an evidence of last scene.
Huh.
Raju Satnami was seen coming out of the room with a bloodstained down. And when the doctor went in, the victim was lying there.
Except the doctor, my lord, no one,
So
there
the
are other
doctor is an
persons,
independent witness. He had nothing to do.
there
with
are other persons, my lord. That person though did not, my lord, witness,
Quality, not quantity of the witnesses.
my lord.
So Raju Satnami, what about the other accused?
Other accused, my lord, there are no allegations, my lord.
PW one had said,
What has he said? But the,
son, Saju had hit on the head of his mother.
that was the earlier incident, madam.
That was
Regarding the incident of murder,
murder, others are not convicted. for
they are not
murder.
convicted.
Not,
For murder. They are not convicted.
They are
for murder.
convicted for the
323.
incident of the morning.
yes, my lord.
Lesser offenses. For Raju Satnami, there is nothing, Mr. Counsel.
Except
This
that
is more than enough. Where is the FSL report?
FSL, I don't think so. It was done.
there is no, my lord.
Let's reconstruct this file also because I have the note. I had seen it. I had.
Even the, my lord, weapon of, my lord,
Public prosecutor MS Jan pays for and is granted a week's time to reconstruct the file. This-
I have the note. I prepared it, but then I don't have.
There is nothing, so far as Raju Satnami is concerned, there is strong evidence of him having been seen coming out of the room with a bloodstained weapon. That is more than enough.
my lord, did offense of weapon was not, my lord, recovered.
Not required. Not required. If the evidence of the witness is sufficient, it doesn't require any corroboration. As a matter of fact, case of eyewitness,
My
the
lord,
witness saw you coming out from that room You had a motive because in the morning also you assaulted the lady. There's a complete chain of circumstance.
my lord. Well, I'll submit
right.
on that. my lord.
Why FSL report is not there?
It was not sent, check out, and check up. Hardly matters are sent in Assam, I have not seen, very few cases I've seen.
Yeah.
The murder weapon or the.
Hardly, there's no match usually.
They hardly send.
Give the guidelines in this case. We'll give the directions.
And
So in Rajasthan, by judicial directions, we have got FSLs established in every district.
This is what is required. And even if it is sent, they report that the things are not in sufficiency. I mean,
Obviously, the link evidence and everything.
Ah.
Our officers need training, madam. Seriously.
And they don't match it.
Give it to.
There's never.
I'll be honest.
That is a. You get link evidence right from the time of Caesar till it reaches back in the court.
Yeah, we do not have, we will get to one side.
Hardly police sent here.
All right, we'll see, we'll re-notify on, list it on 9th, 9th. We'll hear it on 9th. We'll give directions for the FSL and everything.
Yes.
Yeah. Okay.
Oblige.